Hi, very good evening, everyone.
Hi, good evening. Yeah.
Am I audible properly, right? I hope.
Yeah. Perfectly audible. Yeah.
I'm trying to share my screen as well, so just 1 second. My screen is visible?
Not yet. Yeah,
No.
now it's visible. Yeah, perfect. I will
Okay.
just start the session and then I will hand it over to you,
Yeah, sure.
sir.
So shall I
Okay.
stop sharing right now?
Yeah, you can stop sharing. Yeah.
Okay. I was just trying to,
Yeah.
check. Well, everything is fine. Yeah.
So, a very good evening to everyone for joining us on the third day, that is today, in the certificate course on GST, advanced course, which specifically deals with litigation. And we have been covering each and every small section of litigation every day in these 10 days. So today, Abhishek ji has joined us. I would love to introduce our speaker for the day. Uh, Abhishek ji is a practicing lawyer and holds a dual professional qualifications of a chartered accountant and an advocate. He has around 11 years of experience in handling tax litigations, both direct and indirect taxes, before Supreme Court of India and across various high courts across the country. He has also been impaneled as a senior standing counsel for DRI and DGGI, New Delhi. He is a commerce graduate from the prestigious Sri Ram College of Commerce, Delhi, and a law graduate from Campus Law Center, Faculty of Law, Delhi. He is also a fellow member of ICAI. He has been previously associated with many of the top tier firms of the country. He is also he is frequently invited as a faculty on tax laws and insolvency and bankruptcy code by ICAI. He's a regular speaker across various CS study circles all across India. He is based out of Delhi, and today Sir would be joining us. So I would love to facilitate Sir by sharing a virtual memento for Sir as a token of gratitude. So this is a virtual memento presented for you,
Thank you.
sir, to
Thank you.
take out the time, your prestigious time, and share your prestigious time with all of us, sir, to help us understand more intricacies of this litigation that we have. So,
Thank you so much, Siddhant.
yes, sir. Thank you, sir. So the topic for today is the departmental correspondence and proceedings under Section 69, read with Section 132. And sir, we would love you to please take the session and help us understand in more details about the topic, sir. Thank you so much, sir.
Yeah, thank you so much, Siddhant, for introducing me, and thank you, the entire ACAE, for inviting me today as a guest lecturer here, and more thank you for considering me fit to be invited here to have this lecture today with all of you. And indeed, it's been a pleasure, to be here. So, in fact, though I understand that this is a litigation series, which this certificate course on litigation series. So yeah, I think I will be able to justify this lecture. But any which ways, I do also understand that a lot of audience here is also from our professional forum as well, like CAs and lawyers. Am I right, Siddhant? A lot of the audience is already here. So let's try to have it in an interactive way if it is possible, because that way we all can learn more. And as we as lawyers, we always say that we are students of law every day. So every day in and day out we learn something new, and it's a continuous learning process. So we all even though the lecture has been taken by me today, so but if we keep it interactive, so maybe some good things I also learn out of this lecture today. And so thank you so much everyone for inviting me and having me here. And without wasting any more time, so I'll start with the topic, and I'll just screen share. So Siddhant, just can you tell me from the previous two lectures what all topics have already been covered?
Yeah. So we have just a second. Hmm. So the first day was on scrutiny to adjudication, just the basics.
Okay, so
For two,
adjudication is covered.
yeah, and it was just a for two from a scrutiny to adjudication. The second day was departmental audit, inquiries, and summons, and today is the
Okay.
third day.
Okay, great. So yeah, I'll just screen share. Today is in fact a very interesting topic, which personally interests me a lot, is this arrest and summons, etc. Just wait, I'm sharing the screen. So now my screen is visible, right?
Yeah.
It's visible, right? So yes.
Yes, sir.
So today the topic which has been is named as Departmental Correspondences and Proceedings under Section 69, read with Section 132 of the CGST Act. A very interesting topic, a topic which interests me personally a lot, and in fact a lot of my practice is based surrounding this topic. So yes, this is an interesting topic, and why it is interesting is more interesting is that the provisions, when we say 69 under GST, this relates to the provision of arrest. Arrest was something which was completely unheard of in the previous indirect tax regime. No one was experienced of a situation like arrest in the central excise. Yes, customs, there were arrests, and people knew that when there is a violation of a customs act, there were arrests being made. For example, gold smuggling and all that. But for even practitioners who were practicing VAT laws or the central sales tax or the excise, arrest was something which was not heard of. Till you can say 2012, 2013, when after which a few arrests started happening in the service tax, under the service tax laws. Those service tax and excise were intertwined and interrelated laws, but the arrests, a few arrests before GST, which we saw were under the service tax regime, and before that, there was no concept. There was a concept, but there were no actual arrests happening under the excise or the VAT laws. Even under the income tax laws, there is a provision for prosecution, there is a provision for search, seizure, etc., but there is no provision for arrest as such. So when the entire indirect tax regime had a shift from subsumed into GST, so Section 69 was a very interesting provision which we all saw being added into the GST laws. Now, and in fact, if I remember, none of us, when we were preparing for GST laws to set in the country, we didn't realize that this provision has been added. It's a three clause section, Section 69. It has three sub clauses. So we also didn't realize that this three clause section is going to create a terror in the minds of business community across the country. So maybe when GST laws kicked in, we also didn't pay much attention, or we didn't even read this section very carefully, or we didn't anticipate that a lot of actions will be undertaken under this section. But by the time this 2017 GST came in, by the time it was 2018-19, and in fact not 18, also 19, 20 and 21, 2019, 2020 and 2021. These were the 3 years which saw a lot of arrests under GST, and a lot of actions where people were called for summons, they went to record the statements, and they were arrested. So a lot of such kind of actions happened in these 3 years, wherein we as lawyers also started realizing that this section needs to be learned, and we all need to go into the nitty-gritties of this section a lot more than it is being provided. That is where the first jurisprudence under the GST laws, as far as the arrest provisions were concerned, started in the country. So because what happened was that there were arrests started happening in the country, and no one knew what is the procedure of arrest, whether the procedure is right or wrong, etc., etc. All these things started happening, and that is where the jurisprudence started kicking in. So when we say that litigation as far as 69 is concerned, it started, the first landmark case started in somewhere in 1920, and from there it is now evolving day by day, and it has evolved over a period of time. But yes, still issues are pending, and that is where, if we are wanting to learn the litigation under GST, this is one of an important area where we need to focus upon. So as we all know, we'll go slide by slide, and I think if you have any queries, you can uh, keep typing them in the chat box, and we'll take those queries side by side. So GST came in 2017. We all know the various indirect taxes like central excise, service tax, VAT, central sales tax, etc., were subsumed under one law, which is the GST law. This presentation delves into the procedural aspects of inspection, search, and arrest, along with nuances of Section 69, read with 132 of the CGST Act, which pertains to power of arrest and punishment of offences. So, when we read 69, as I said previously as well, 69 is just a three-clause section. 69 has 69.1, 69.2, 69.3. But this three-clause section is intertwined with a lot of provisions under Section 132 as well, under a lot of provisions of the CRPC also. CRPC also now has subsumed into BNS. And just this mere three-clause section is intertwined with a lot of other provisions of the law. And that is where understanding the nitty-gritties becomes important. So before we delve into the provisions of the GST Act, just to set the tone right for today's lecture, and for just to set the tone for the provisions under and how these provisions were shaped, let's first go into a bit of jurisprudence on arrest under the erstwhile laws. So under the erstwhile laws, if you want to study the jurisprudence, the major judgment, the one of the major landmark case which happened during the previous indirect tax regime was of Om Prakash Agarwal, which was a Supreme Court judgment. In this judgment, this was, I think, 2012 judgment. In this 2012 judgment, the provisions of arrest as far as the Central Excise Act were interpreted, and the Supreme Court said that various offenses under the provisions of the Central Excise Act, the question before the court was whether all the offenses under the Central Excise Act are non-cognizable. The word to note down is non-cognizable. And bailable. So the court interpreted the provisions of Central Excise Act to say that an offense which is punishable with the imprisonment for 3 years and upwards, but not more than 7 years, has to be shown cognizable and non-bailable. The definition of non-cognizable offense in Section 2I of the Code makes it clear that a non-cognizable offense is an offense where the police authority has no authority to arrest without a warrant. So the Supreme Court in this case interpreted Excise Act to say that all the offenses up more than 3 years of punishment but less than 7 years of punishment have been shown as cognizable and non-bailable, which is not right. The definite non-cognizable offense is an offense where the police officer has no authority to arrest without a warrant, and because all non-cognizable offenses are non-bailable. Now you have to note down these 3-4 words which I'm saying, like cognizable offense, non-cognizable offense, bailable offense, and non-bailable offense. These 4 phrases, they are not defined in the GST Act. We have to import the meaning of these phrases from the criminal laws, and I will tell you what is the meaning of these offenses, these phrases. But as of now, just remember that these 4 phrases also become important when we talk about the provisions of arrest under the GST laws. So now, when the Supreme Court interpreted this, the provisions of the Central Excise Act, and also held various provisions to be ultra virus, there were a lot of amendments which happened in the Central Excise Act and Customs Act, where the monetary limits were prescribed. So if you see under the GST also, there are monetary limits for the purposes of arrest. The background for having these monetary limits was this Om Prakash judgment. Before the Om Prakash judgment, there were no monetary limits as far as the arrest provisions were concerned. Conferred after this judgment, the acts were amended, and the cognizability and the non-cognizability, bailability, non-bailability were linked to the monetary limits. The second important aspect, which may come to the mind of a lot of people, and the first question that comes to the mind is for example, there is an evasion of tax. Now, the evasion of tax usually, as we understand, leads to a issuance of a show cause notice. Show cause notice is usually known as the adjudication proceedings. So, for example, a person is undergoing an adjudication proceedings, or there is a proposal for initiating of adjudication proceedings, whether during that time you can initiate arrest or not. So the first of such a kind of a case, which was seen in the service taxes I was referring during 2014-15, was seen in the case of Make My Trip and Clear Trip Private Limited, wherein for the first time, what had happened was that there was a investigation which was launched by the DGCI, which is now DGGI, Directorate General of Central Excise Investigation, against these 2 companies. And during the course of investigation, they found that there has been some evasion of tax. They were keeping the amount of tax and not depositing the same with the government. So they arrested some people from the management of these companies. And when the DGCI arrested people from the management of these companies, the arrest was challenged before the High Court, Delhi High Court. So Delhi High Court in this case said that the power of arrest is to be used with great circumspection and not casually. It is not to be straightaway presumed by DGCI without following the procedure under Section 73 and of the FA that the person has collected the service tax and retained such amount without depositing the same with the credit of central government. We all know that 73, this is all adjudication. So what in Crux and in Clear Trip case, the court said that coercive measures, including effecting any arrest, would arise only when investigation has been completed and on launching the prosecution. So in this case, the crux was basically the High Court said, Bombay High Court as well as Delhi High Court, they said that you can't arrest a person till the time adjudication is complete. And adjudication is only after the adjudication is complete, there is a quantification of the demand as far as the taxpayer is concerned. And only once the demand is quantified, you are able to assess that whether this person needs to be arrested or not. So because the rationale was that, for example, today you think that there has been evasion of tax, you arrest a person, and later on you turn out that the evasion is only for 10 lakh rupees. For 10 lakh rupees, you can't simply arrest a person. So that is why the adjudication, at least a show cause notice, is very important before you arrest a person. Unless the show cause notice is issued, you should usually not arrest a person unless the person is a habitual offender, etc., etc. So you should not arrest the person. So this judgment of Delhi High Court in Make My Trip was affirmed by Supreme Court as well. Then the other important judgment in the previous regime was on Agarwal Iron Industries, Supreme Court, on the phrase reasons to believe. So whether the competent authority had formed the opinion on the basis of any acceptable material or not, as is clear as crystal, the High Court has not even remotely tried to see the reasons. Reasons, needless to say, can be recorded on the file, and the court can scrutinize the file and find out whether the authority has appropriately recorded the reasons for forming an opinion that there are reasons to believe to conduct search and seizure. So under GST also, this judgment is important because of the word phrase reasons to believe. In 69 also, reasons to believe word is there. So this judgment, basically landmark judgment, said that reasons to believe, even if you don't provide it to the person whom you are searching or whom you are arresting, that reasons to believe has to be recorded in the file. And the courts, while scrutinizing the legality of search and seizure or legality of arrest, etc., can scrutinize the file and find out whether the authority has appropriately recorded the reasons for forming an opinion. In this particular case, the High Court had not even checked whether the reasons to believe were recorded or not. So reasons to believe, as per the jurisprudence which has come, prior to the GST regime, is that reasons to believe should be something substantial. Reasons to believe should not be simply that the officer thinks that I don't like this person, I want to arrest him. Or maybe in just one line saying that I feel that this person has evaded tax, I am arresting him. This cannot be a reasons to believe. Reasons to believe has to be proper, and the reasons to believe should give a formation of an opinion that these are the reasons, basis this reasons I am forming this opinion that this is the fit case for affecting the arrest or for affecting the search and seizure, etc. So this is as far as the reasons to believe is concerned. Now another important judgment, Radheshyam Kejriwal, even though this judgment is in relation to the FEMA laws, not even FEMA, actually FERA. So, but this becomes important because this judgment says that adjudication and prosecution are distinct and separate. So you have to remember this judgment because in GST also, the way we are now, the jurisprudence is forming, they say that there is one step known as adjudication. The other step is prosecution. And these are separate. And arrest can happen between these two stages, prior to adjudication, prior to prosecution, etc. But if arrest has happened, prosecution is must, right? So as you Siddhant told that you have done the adjudication part of the GST. Adjudication part, usually when we say adjudication, is issuance of a show cause notice, and then you file your reply, etc. Then the adjudication, like finalizing of the order, wherein the tax is actually quantified, the allegations are finally determined, etc. This part is known as adjudication. The prosecution is a separate part. Adjudication is done by the GST officers, whom we call as proper officers, and prosecution is done by criminal courts. So this is a difference. Abhi aap, at this stage, just understand this. When we move on to the 69, I will explain these processes in detail. But you have to understand as of now that adjudication and prosecution are two separate things. And arrest, in cases of arrest, prosecution complaint will be filed. However, there can be prosecution without arrest also. So to get a prosecution complaint filed, arrest is not mandatory. Even if the person is not arrested during adjudication or after adjudication, but there has been offenses committed as per 132 of the Act, the prosecution still can be maintained. Now, broad principles of jurisprudence on arrest which emerge from the erstwhile laws. Yes, these are also important, to know. The officers under various tax laws, as such as Central Excise Act, are not police officers to whom Section 25 of the Indian Evidence Act would apply. Now, this is very important. The officers of the taxation statutes are not police officers, to which Section 25 of the Indian Evidence Act apply. Indian Evidence Act, of course, is now the BSS. So what does this statement means is that these are not police officers. So I'm sure many of you know that a statement made or a confession made before a police officer is not admissible as evidence under the law when a criminal trial is happening. But that is not the case when tax laws are concerned, because they say that the officers under the tax laws are not police officers. So even if you make any confessional statements, even if whatever statement you make can be used as evidence against you. So like in normally also we have seen that when a client goes for attending summons under Section 70, they record his statement, and that statement tomorrow is used for the purpose of show cause. Also, that statement is tomorrow used for the purpose of this prosecution also, and maybe arrest also. The next is that the power conferred upon the officers appointed under various tax enactments for such are actually intended to aid and support the main function of levy and collection of taxes. So why they say they are not police officers? They say that the officers appointed for the purpose of search, for the purpose of levy and collection of taxes, the powers given to them for search and arrest are only to aid and support their main function. So that is why they cannot be equated to the police officers under the criminal laws. Now, this is third is also important. A person against whom an inquiry is undertaken under the relevant tax law does not automatically become a person accused of an offense until the prosecution is launched. So that is why they say, and maybe you have done a summons also yesterday, under Section 70, when you are appearing and under the summons, it is not an investigation, it is only an inquiry. And inquiry per se is a defined term, it has a specific connotation under the criminal laws, saying that this is only an inquiry. And Section 70, as you have done, is a kind of a civil proceeding. So at the stage of inquiry, you do not become a person accused of an offense. So when you don't become a person accused of an offense, there is no protection of Article 23 also. Now, Article 23, 20 subclause 3 of the Constitution of India is a very important article, which protects any citizen against self-incrimination. So, usually the first thing that comes in mind when tax laws, this summons, etc. concerned, that I go there, they made me sign certain statements, etc. What is the validity of those statements? So, under taxation laws, they say that the person who is summoned for an inquiry, since they are not the persons accused of an offense, so that is why they are different from the persons who are called under 161 or 91 of the CRPC, now BSS. They are not equivalent to those persons accused of offense. That is why whatever they say can be used against them. There is no protection under Article 20 subclause 3. Article 20 subclause 3 only gives a protection to the person accused of an offense and no one else. Right? So these then as far as search and seizure is concerned, power of search and seizure is a strong investigation tool in the hands of revenue authorities, which gives enormous opportunity to gather evidence and unearth suppressed information to properly identify evasion of tax and contravention of any provisions of the law. Such action is having an effect of interfering into one's independence, in addition to having a chance of hampering business activities. Therefore, while exercising these provisions, utmost care is required to be taken, especially the documentation part related to such actions, so that evidences collected during investigation should not fall the victim of improper documentation and procedural defects. Section 67 to 72 deal with the inspection, search, and seizure. So with the background of these backgrounds, the jurisprudence which was there under the erstwhile laws, which we still use in courts while interpreting provisions of the GST, arrest, search and seizure, etc. And what is the purpose of we knowing these provisions is that the jurisprudence is always based on the previous jurisprudence. So with these principles in mind, now we move to the provisions of inspection, search, seizure, arrest, etc. under the GST laws. Now under GST laws, which is the CGST Act, and corresponding state, etc. also, chapter 14, these sections are in there. Section 67, 68, 69, 70, 71, and 72. Offenses are mentioned in 132. Now, while our today's topic is only 69 and 132, but still to understand the layout of the provisions, I'll just go through in brief about the rest of the sections. What do the sections mean? And then ultimately we'll come to powers of arrest. 70, I understand that you have done yesterday. So 70 is not required. Just my screen. Is the screen share clear?
No, the screen share.
Is the screen share?
Yeah, it is clear.
Okay. I think it was disconnected in between. Sorry. Yeah. So 67 talks about power of inspection, search, and seizure. And you have to keep in mind that inspection is different, search and seizure is different. Under 67, 68 talks about inspection of goods in transit. 69 talks about power to arrest. 70 is summons. 71 is access to business premises. And 72 is officers to assist proper officers. Now, prosecution, I'll come this part on a later stage. 67 section has two subsections. Subsection 1 talks about the power of inspection. And in inspection, the broad points you have to keep in mind is that there must be, first of all, whenever there is a departmental correspondence regarding the inspection, etc., the things which we have to bear in mind and which help us while preparing our litigation strategy as well is that the authorization for inspection has to be given by an officer of the rank of joint commissioner and above. So whenever we were talking about litigation and whenever we're talking about departmental correspondences, be it starting from inspection, search, etc. Even for the purpose of adjudication summons, etc. We have to first bear in mind, and what the thing we have to first see is that the person who is issuing the same is the person who is authorized under the act. So, for example, an authorization for an inspection given by a superintendent is completely invalid. It's completely illegal in the eyes of law. If you get an authorization for inspection which has a signatures or it has been authorized by, say, superintendent, you can simply refuse the inspection. And if they still go ahead and do the inspection, you can challenge the same in the court. So these things which I'm just pointing out are very important as far as the litigation part is concerned. Second thing is that he must have noted in his file. Obviously, nowadays the problem is they don't share the reasons to believe, but the reasons to believe should be on his file. And the reasons to believe should be any of the following 6 reasons, like suppressing any transaction, suppressing the stock in hand, claiming of excess input tax credit, indulging in contravention of any of the provisions of the law to evade tax, or that the transporter is keeping the goods which has escaped tax, operator of a warehouse, etc., which is keeping goods which has escaped tax. So the reasons to believe as far as the inspection is concerned should be for all these reasons. Then the authorization for the inspection should be in form INS 01. This is the form prescribed for the purpose of inspection. This inspection form has to be in this format only. The other important part which differentiates 67 and 62 majorly is, hello? Yes. So inspection can only be of a place of business, not any other place. So what is a place of business? Place of business is usually your registered place of business for the places you have taken registration, or for the place of business where you have taken additional place of business, etc. And place of business is defined under section 285 of the CGST Act, meaning thereby go down or any other place where a taxable person store his goods, maintains his books of accounts, and place of agent. And usually, as far as the registration is concerned, you have to take registration for all these places of business. So inspection can usually be only carried out at the place of business only and no other place. However, when we move to section 67 subclause 2, which talks about search and seizure. Search and seizure can be initiated at any place. It is not confined to the place of business. Again, the authorization of search and seizure has to be given by the officer of the rank of Joint Commissioner. And above, reasons to believe that the goods liable for confiscation are situated in a place, books, documents, or something which is useful or relevant for proceeding under the GST laws are situated in any place. And then this authorization has to be in the form INS 02. So this is the major difference between 67.1, 67.2. 67.1 is for the inspection. Inspection can be carried out only at the place of business, whereas a search can be carried out under the any place. 67.2, search can lead to confiscation also. Search can lead to, they can come, seize your goods, seize your mobiles, seize your documents, etc. And then 67 though has total 12 subclauses, and then they on all the clauses there is a procedure mentioned for when you can get your seized articles back, and how do you apply, how much time they can retain, etc. All these clauses are there in 67, so you can read them. But this is the as far as the inspection, search, and seizure is concerned. Now, When we talk about goods liable to be confiscated, during the search and seizure proceedings, when there are certain goods which are liable to confiscation, there is a section 130 of the CGST Act, which prescribes that which are the goods liable for confiscation, and these are the three categories of goods specified under 130 of the CGST Act, which are liable for confiscation, which are if supply is made in contravention of any of the provision of the GST law with intention to evade tax, or if goods are not accounted for on which tax is liable to be paid, or if goods liable to tax are supplied without having applied for registration. So these are the three categories of goods which are liable for confiscation as per the section 130 of the CGST Act. Now moving on to section 68. 68 talks about inspection of goods in movement. Rule 138 of CGST rules. We all know this, like the consignment, which are usually stopped in between, and e-waybill issues, etc. So these are covered under 68. The driving power is from section 68 of the CGST Act, which says that any consignment value of which exceeds 50,000 rupees may be stopped at any place for verification of documents prescribed for such consignments. If during verification it is found that goods were removed without prescribed document, or the same are being supplied in contravention of the provisions of the Act, the same can be detained or seized and may be subject to penalties. When we talk about penalties, section 129 of the CGST Act talks about penalties. So 68 read with 138 of the CGST rules prescribes for documents required to be carried in by the person in charge of the conveyance, bus, truck, lorry, or any other invoice, and copy of e-waybill. These are the mandatory requirements. And I'm sure in Calcutta also, or other places also, we see, we might have been seeing cases of 129 penalties where the transporters' vitals are stopped, etc. So all these cases are covered. These provisions are 68, 129 of the CGST Act read with Rule 138 of the CGST rules. Now we move to section 69, which is actually the topic, the main topic for today. Section 69 is the power to arrest. And let me just zoom the PPT a bit. Now, if you read section 169, I have tried to bifurcate section 69 because 69 actually leads to, links itself to corresponding section 132 of the CGST Act. Now, let me first read from the BEAR Act how this section is worded. And if you all have BEAR Acts, you can also open your BEAR Acts with you. 69 is power to arrest, wherein the first subsection is where the commissioner has reasons to believe that a person has committed any offense specified in clause A or clause B or clause C or clause D of subsection 1 of section 32, which is punishable under clause 1 or 2 of subsection 1 or subsection 2 of the said section, he may, by the order, authorize any officer of settled debts to arrest such person. Now, this section talks about offenses A or B or C or D of subsection 1 of 32, punishable under 1 or 2 of subsection 1 or subsection 2, then the arrest can be authorized. First of all, the first ingredient of this section, which we all need to notice, who can authorize arrest? Commissioner. And when it's a case involving DGGI, it is usually the director or deputy director, because there is a notification where the officers of DGGI are also, the powers to be exercised by commissioner are given to the officers of DGGI as well. So the first and the foremost is who is authorized to do the effect the arrest is commissioner, and forget the column number 2, 3, 4 as of now. When the commissioner has reasons to believe, this is also important. So reasons to believe, as I said, Agarwal Iron Industries Supreme Court we just read. So we have to track the jurisprudence on how reasons to believe has to be formed. That any person has committed an offense specified, I'll come to this later on. He may by order authorize any officer of the central tax to arrest such person. So the commissioner is the person who has to authorize. The reasons to believe has to be recorded by the commissioner, but to actually go and arrest, he may authorize any other officer of the central tax. He may be a officer of the lower rank also, assistant commissioner, etc. But what is important, for example, your client is arrested, etc. What is the first things we usually see is that whether the authorization is by the commissioner, the reasons to believe has been recorded by commissioner or the officer to whom he has authorized. The reasons to believe has to be recorded by the commissioner. And then he can authorize any officer of the central tax to arrest such person. Now, what are the cases under which the person can be arrested, and why I have, put in 132 is also here is because it seems a very small subsection, but if you link it with 132, it becomes quite a big, provision to understand. Now it says, if you read further, where the commissioner has reasons to believe that a person has committed any offense specified in clause A or B or C or D of subsection 1 of 132. So what is this A? A is supplies any goods or services or both without any issue of any invoice in violation of the provisions of this act or the rules made thereunder with the intention to evade tax. So this is where, which we say, usually we, in common parlance, we refer to as clandestine removal or maybe the supplying without registration cases, etc. Right? Now, B is issues any invoice or bill without supply of goods or services or both in violation of the. So A is you supply goods or services without issue of invoice. B is you only issue invoices and not supply goods, which is nowadays the new term developed by GST is goodsless invoices. So this is the terminology used by GST department these days. Third is avails input tax credit using such invoice or bill referred to in clause B or fraudulently avails input tax credit. So जिसने, if someone has issued an invoice in clause B, he is also committed an offense under 132 1B, and the person who is availing the credit of such invoice has also committed a offense. Then fourth is collects any amount as tax but fails to pay the same to the government beyond a period of 3 months from the date on which such payment becomes due. So these are the cases where you collect tax, you collect money representing as tax from the government, and then you don't pay it to the government beyond a period of 3 months from the date on which the payment becomes due. So this is also an offense prescribed under 132(1)(d). So if any of these four offenses are committed, these are the four offenses committed under 132(1)(a), B, C, D, which is, and this is, commission of these offenses is not just enough, which is punishable under clause 1 or 2 of subsection 1 of section 132. So if you will see section 132, if you can open your Barrett's also simultaneously, you will see that 132 is divided. There is a 132(1), which has subsections till L, and then it says shall be punishable, and then it has further 4 subclauses which are in this format. So if these the first, but only for the purpose of arrest, with the purpose of section 69, the first 4 offenses, which is A, B, C, D, and that too, if they are punishable under a particular head of 1 or 2, only then the person can be arrested. So what is this? 1 or 2, in cases where the amount of tax evaded or the amount of input tax credit wrongly availed or utilized, or the amount of refund wrongly taken exceeds 500 lakh rupees, which means 5 crores. So where the amount of tax, any of the offense 1, 2, 3, 4 evaded, the amount of evasion involves more than 5 crore rupees, within, then you can arrest. Or in cases where the amount of tax evaded or amount of input tax credit exceeds 200 lakh rupees but does not exceed, so this limit is for 2 crores to 5 crores with imprisonment for a term which may extend, or subsection 2 of section 132, where any person is convicted of an offense under this section, is again convicted of an offense under this section, then he shall be punishable for the second and for subsequent offense with a term which may extend to 5 years. So now this says that if you have committed an offense, say A, B, C, D, nahi, but say I or L, and you were prosecuted for it, convicted for it once under the prosecution, but you convict it again, right, irrespective of the fact that it is not covered here, then you can be arrested by the officer. So to recapitulate, for the purpose of effecting arrest under 69, the first and the foremost is commissioner has to do it. Reasons to believe has to be recorded by the commissioner. He can authorize any officer of central tax to do the arrest, but only for the violation of or the commission of offenses under section 132(a), B, C, D, and when the amount exceeds either 5 crore or it is between 2 to 5 crores, or if irrespective of the amount or irrespective of the ABCD clauses, any offense, the second time if it has been committed by a person, then he can be arrested irrespective of the monetary limit involved, etc. So this is how we have to read section 69(1). Looks very small section, but it is linked to a lot of things. So we have to be very careful while determining whether the arrest can be made or not. And usually the first, and while doing the litigation, as far the arrest is concerned, we have to see that usually right now, in practically in cases when we see the arrest memos issued by the commissioner, they simply say, and which is also now pending challenge before the Supreme Court. I'll come to that part on later on. But they usually, if and when we see the arrest memos these days, or in fact, when we saw the arrest memos back in 2018, it simply says, whereas I have reasons to believe that, sorry for my handwriting here, this so and so has committed an offense under clause A or B or C or D of 132, and the amount involved is 10 crores. They would write this in their arrest memo as a reason to believe, and they will effect the arrest of the person. While this practice is not right, but GST authorities have been doing it. The same is pending challenge before the Supreme Court as well. And I'll come to that part later on, what is the subject of challenge. But this is how the arrests are made practically. But so when we go for a bail, or when we are litigating about the legality of arrest, the first and the foremost point is that where have they specified which they have to at least specify under which of the provisions of A or B or C or D I fall. Because settled principle of law as far as the criminal jurisprudence or criminality of things are concerned, that under a criminal action you have to be very specific about the allegation. You can't simply say that I have reasons to believe that clause A or B or C or D is triggered. You have to be very specific about the clauses which you are triggering. So a lot of times we have argued it, a lot of times courts have realized it, and even there are a lot of judgments of Allahabad High Court, in fact, or Punjab Haryana High Court. You will see on this aspect that in the arrest memo, the officer is himself not clear as to which of these sub clauses, this falls. So in that terms, they have given bails also, and they have allowed people to be released, and they have in some cases declared arrest illegal as well. So this is as far as 69(1) is concerned. So now moving on to, and now from here, just keep in mind this 5 crore and 2 crore because it gains relevance under the next subsections. 69(2) says, and let's read 69(2) now, where a person is arrested under subsection 1 for an offense specified under subsection 5 of section 132, the officer authorized to arrest the person shall inform such persons of the ground of the arrest and produce him before the magistrate within 24 hours. So it says where the person is arrested under subsection 1 for an offense prescribed under 132(5), he has to be informed of the grounds of arrest and produced before the magistrate. So what is important is 132(5) providing grounds of arrest and producing him before a magistrate within 24 hours. Now, 132(5), let's again move to 132(5). 132(5) says the offenses specified in clause A or clause B or clause C or clause D of subsection 1, these one, and punishable under clause 1, clause I, the Roman 1 of that subsection shall be cognizable and non-bailable. So these 4 offenses, if falling under this, are cognizable and non-bailable. And this is the 5 crores is the major problem in GST, because more than 5 crores, the offense becomes cognizable and non-bailable. Now here we assume the importance of the words cognizable. Under the criminal laws, it simply means officer can arrest without a warrant. And non-bailable does not mean that the bail cannot be given. Bail can be given, or in other words, non-bailable is not an offense where the bail cannot be given. Non-bailable simply means that bail can't be claimed as a matter of right. So bail can be given. So when the offense is a bailable offense, the bail has to be given as a matter of right. And non-bailable does not mean that the bail cannot be given. The bail can't be claimed as a matter of right. The court will see the facts and circumstances of the case and then give you the bail. Cognizable means the officer can arrest without a warrant. Non-cognizable offense means that the officer needs permission of a magistrate to effect the arrest. And in cases of non-bailable and cognizable offenses, the person has to be produced before a magistrate within 24 hours. This is the crux of section 69, subclause 2. Do we have any queries till now?
I have one query.
Yes.
Yeah. So, power for inspection, as we were talking, there are only 4 reasons for inspection, for which inspection can initiate under INS 1. What I have personally seen in one of our cases, that the team from the department came with INS 1, and it was written for one of the following reasons, and all the 5 reasons were written down. And they refused to take any. They were like, we will take it later on. So how to challenge that? So they are like, we will first do the search and then we will take.
Then we call it a roving and fishing and query under our practice. So वो कहते हैं कि हम पहले ढूंढ लें, फिर जो हमें मिल जाएगा उसके हिसाब से we'll take.
So how can we challenge this?
So yeah, in such cases, Siddhant, when there are officers at your door, obviously, at that time the pressure is too high, and they will not, listen to all this, and they will inspect your premises, be that as it may. But it's always better to take a photo, etc., copy of the form which they give you unticked or unsigned. And later on, we have also challenged inspection searches before the high courts in a lot of cases, and in some cases the high courts have actually declared the inspection and search to be illegal.
But the problem is, the problem is they won't let us take a photo or a photocopy or anything. They're like, this is our private, this is confidential, you cannot take any photo or you cannot copy it. You just sign it that you have seen it. That's it. So that's the problem that we face.
But then you have to go before the court, try it, you have to try to take as much evidence as you can, that they didn't allow us, etc. Your colleagues and all can be evidence to it, and give all those things on the affidavit. And the only remedy is to go before a high court and get the inspection and search quashed. Though it doesn't happen in every case. We have seen cases also where court says that you have signed it, you saw it. The courts don't understand the nuances, sometimes कि ground realities क्या रही होंगी उस time पे. But and sometimes they are not very keen on quashing it also, because The problem is that inspection search has already happened, so damage has already happened. So, but what to do later on? So in that, sometimes the courts don't really do it, but there are cases where they have been declared illegal as well. For example, I'll give you another example where GST authorities came for search, and they seized cash also from houses or business premises, etc. And they said that we can very much seize the cash. So all these things, like seizing of cash particularly, was challenged before Delhi High Court 2 years back. And Delhi High Court, after analyzing all the provisions of the GST Act, etc., they said that under no provision in the GST Act, the officers of GST are authorized to seize cash. And they directed the GST authorities to, give the cash back. The income tax authorities or the ED, etc., they can seize cash, but GST officers cannot. So definitely, उस time पे जैसे you can't explain them all these things, but try to gather all the evidences which you can, and which can be later put on an affidavit, including the list of affidavits of your friends, family members, etc., who have seen all these things, and then these things can definitely get challenged. So that's my take on that.
Thank you.
Any other query till now? Queries are welcome, because that gives me also feedback whether you guys are understanding or not. Okay.
In that case, we can take the queries in the end if we don't
In
have
the
queries
end,
now.
okay. No problem. No
And if
problem.
anyone
Sridhar.
has a query in between, they can keep it on the chat so that we can.
Yeah, you can just write them on the chat box. So yeah. So then I'll can I take a 2 minutes break and just be back?
Yeah, sure.
Yeah, I'll just take a 2 minutes break. 6:07. So I'll just be back by 6:10. Right? I'll start at 6:10.
Yeah, sure.
Thank you. Yes. Yeah. So can we start again?
Yeah, we can. Yeah.
Okay. Yes. So 69 one we did 69 2 the offenses more than 5 crores cognizable and non-bailable, and because they are cognizable and non-bailable, you have to be produced before a magistrate within 24 hours of effecting arrest, and you have to be informed of the grounds of arrest, etc. Now 69 3 again very important. It says that subject to the provisions of Code of Criminal Procedure, now BNSS, where a person is arrested under subsection 1 for any offense specified under subsection 4 of section 132, he shall be admitted to bail or in default of bail, forwarded to the custody of the magistrate. So here they say if you are arrested for an offense which is specified under subsection 4. Now, what is subsection 4 of 132 says? It says that all the offenses under this set. So, all offenses except subsection 5, which deals with A, B, C, D above 5 crores. So, with this exception, all are non-cognizable and bailable. So, what does it mean is that even the offenses here, which are between the 2 to 5 crores of limit, etc. So you can only be arrested for these two offenses, which are more than 5 crores or 2 to 5 crores. So 2 to 5 crores, the offense is a bailable offense. 2 crore to 5 crores. In fact, 4.99 crores is a bailable offense, non-cognizable offense. He shall be admitted to bail. So the commissioner himself has the power to give you the bail. And if you don't want bail, some people can't give the bail bond, etc., be forwarded to the custody of a magistrate. Right? So this is as far as 69(3)(a) is concerned. And then it says, in case of non-cognizable and bailable offense, the deputy commissioner or the assistant commissioner shall, for the purpose of releasing an arrested person on bail, have the same powers and be subject to the same provisions as an officer in charge of a police station. So this provision basically means is that the commissioner authorizes arrest, but the offense was a bailable offense. So the officer under him, for example, deputy commissioner or the assistant commissioner, they have the powers same to an officer in charge of a police station, but only for the purpose of releasing an accused person on bail, or otherwise that means forwarding to the custody of a magistrate. So only for this purposes, they have the powers of an officer in charge of a police station. Which are these powers? These are usually taking off the surety bond, bail bond, and releasing you on the bail. Practically, I haven't come across a case where the amount was 2 to 4.9 and they arrested also and they released on bail also. I have never come across such a case. Usually, practically all the cases fall in 69(2), where the offense is non-bailable. They figure out an amount of more than 5 crore rupees and then they arrest the person. They produce him before the magistrate. Now, a summary of these provisions. 69. So if the tax evasion is exceeding 5 crore rupees, the punishment prescribed is up to 5 years and fine. The category is a cognizable and a non-bailable offense. Cases falling in clause 2, which was 200, more than 200 lakhs. Tax evasion exceeding 2 crores, but not more than 5 crores. Punishment is up to 3 years and fine. non-cognizable and bailable offense. If you fall in subsection 2 of 132, then convicted of an offense, again convicted, then the punishment is 5 years and it is a non-cognizable and depending on the earlier offense. So this is the summary. Now, the question which may come to you as far as litigation is concerned is, what happens after the arrest? So once a person is arrested, I'll explain here. Once a person is arrested, for this, he is taken to the magistrate. Now in Delhi, it's a metropolitan magistrate. Once he's arrested, they will inform him, they will give him a memo of arrest. Grounds of arrest. They will inform one family member, right? And after this is done, and while on way of the magistrate, I'm just telling all of you how this practically happens. During this time, they also take the accused to a hospital for a medical checkup, just to ensure that he is not suffering from any problem at the time of making arrest. And they can, they have to make a report that the person was healthy when he was produced before the magistrate. And there are no, basically marks of any beating or something like that. Because sometimes earlier these officers were famous for hitting people also, beating people also. That is why they take to the hospital. And then before the magistrate, the process is they can either file an application for their own custody or an application for judicial remand. The application for custody, usually I have not seen in GST, because there are practical, when they apply for custody of their own, they have to keep the accused with them for, say if they apply for 7 days or 3 days, etc. They have to keep the accused with them. I have not seen this practically happening in GST because of the infrastructural problems, and they don't, because it's not like a police station. They don't have a lockup. So this is akin to, this custody is usually in criminal laws known as a police custody, where they keep the accused for some interrogation, investigation, etc. in their police station, and during the night he's sent into a lockup, etc. GST authorities and GST officers, there is no concept of a lockup, etc. So I've never seen they asking for the custody, GST custody of the accused. Before the magistrate, they usually file an application for judicial remand. In judicial remand, they obviously will say that we have arrested this person. This person is accused of an offense which is cognizable and non-bailable. We have reasons to believe he has done so. So usually the grounds of arrest, remand application will be same. And the amount involved is more than 5 crore rupees, and please send this person to judicial remand. As far as the criminal jurisprudence is concerned, the idea for sending a person in the judicial custody is, the judicial custody is usually he's sent to a jail. He's in the custody of a magistrate and the judicial officer to protect him from tampering evidence, when the person is at a flight risk, or he may be required. We don't want to send him back to these where he can influence other witnesses, etc. That is the idea as far as the academic tenor of judicial remand is concerned. And when the judicial application is filed, usually you can file a bail at this point of time before the magistrate, or you may simply oppose the judicial remand. Judicial remand usually is given for 14 days. If you oppose it, I've seen cases for less also. But now here again is a very, legal issue involved in GST. Some people in some states, there is a concept, and we have to understand this from a perspective that magistrates are not trained for GST law. They are not trained. They don't know they're not trained for the nuances of GST law. And in the GST laws, if you've seen 69, it's a 3-clause section. It doesn't prescribe a procedure for bail, etc. And it does not even say that the provisions of CRPC will apply, etc. So what do? You borrow certain provisions from the CRPC, you don't borrow certain provisions from the CRPC, etc. It's a lot of gray area even as on date. And this is one of another major contention which is pending before the Supreme Court. But what practically is happening in last 4 or 5 years is, before the magistrate, they file an application for judicial remand. It is usually granted. I have never come across a case where the judicial remand application is rejected. Legally, it can be rejected if the magistrate feels that there is no reason to keep this person under the judicial remand. The magistrate is empowered to reject the application for judicial remand. And if the magistrate rejects the application, the accused walks free. But I have not come across any case where this has happened with me, at least in Delhi, that GST people arrested someone, they produced him before a magistrate, took him for a judicial remand, and it was rejected. No, never happens. So ultimately, you have the option of filing a bail or opposing the remand. Now, opposing the remand application also, in some states, it is not allowed, which I have been told, as a matter of, because magistrates usually are under the state as per the criminal laws are the state subject, so magistrates are trained by the state amendments and all. So in some states there is no practice to oppose a judicial remand application, and the magistrates don't allow it, while in some states it is allowed. It is again a matter of contention. We have argued before the Supreme Court that you should allow the opposing of a judicial remand application. In Calcutta, I am told that it is not allowed. So in Calcutta, magistrates don't allow you to oppose a remand application, judicial remand application. So the only option you have is filing a bail application. Now, bail application again decided as per the own local court procedure. But usually, since the it's an offense only involving 5 years of punishment, as per the criminal provisions, there is a 60-day default bail rule. But this 60-day default bail rule is not, followed under GST as of now. This is again a gray area. And if I start talking about gray areas, there are a lot of gray areas, because there is just one section containing 3 clauses which gives a power to arrest, but it does not specify, sadly, how to get out of the situation. And when it does not specify how to get out of the situation, this leads to a Pandora's box of issues that arise when there is bail, when there is default bail, when there is remand, etc. A lot of things. Now, during the judicial remand, when the person is in 14 days custody, usually the GST officers also file an application for interrogation or maybe inside the judicial custody. So what is that procedure is? The GST officer will go inside the jail, seek permission from, like first seek permission from the magistrate, then the magistrate grants permission for say 2 hours, 5 hours every day. They go and they record the statements inside the jail, so that the process which they have to do it during the custody, which is not guaranteed, can be done during the judicial custody also, but by way of permission of the judicial officer. And it is always better because it is the jails are monitored under courts, and so there is no chance of any wrongdoing happening with the person who is being interrogated. So this is the practical aspect of how the arrest is done and what happens thereafter. What happens thereafter is, because the law does not prescribe any mechanism, does not even say that these all provisions apply. There are a lot of issues, a lot of gray areas, which we are expecting. There's a judgment which is we are waiting for a judgment in Supreme Court where all these provisions were challenged, etc. We are expecting clarity on this procedural issues. Now, 670, I believe you have already done yesterday. 70 is a power to issue summons. Summons, again, as I previously also said, are for the purpose of inquiry. And to, so summons in the section 70 is a kind of the first summon you get. In summons also, you will have questions as to, it is a wait summon, what should I reply in the summons? If you see, they write section 70, whereas hereby issue summon to come to this office on sponsored date for, there is only one 3-word written, to tender statement. To tender statement on what, etc. Nothing is mentioned usually in the summons. But summons here is a kind of a civil proceeding as far as the inquiry is concerned. Now the problem which started coming under the GST laws was that the person was summoned to record a statement. Once they record a statement, or maybe he made some confessions, maybe he genuinely made some confessions, they arrest him. That is where the problem in GST started. The summons became a terror kind of an environment. People were afraid to attend summons because everyone thought that we'll go attend summons and they will arrest us. So it's a very unique kind of a law wherein someone is called as a matter in a civil proceeding before an officer under an inquiry to give certain statements, and that inquiry all of a sudden turns into a criminal proceeding where the person is arrested. So there is some level of disconnect between 69 and 70, which sometimes baffles the legal minds and the senior advocates we deal with, etc. That what is this kind of a situation where you go for a civil proceeding, you are giving a statement as a civil proceeding, and that by evening it turns out to be a criminal proceeding. 70 goes to 69 and you are arrested. Now, recently, the Finance Bill 2024, when we hear about things like ease of doing business, etc., they say summons, because sometimes were issued and they said that companies or their management could not go, etc. So now they have allowed an authorized representative to attend the summon and state the truth. A very important amendment which they have tried to bring out is they have added a section 1A saying that the all persons summoned shall be bound to attend either in person or by an authorized representative. As such officer may be direct, and the person so appearing shall state the truth during the examination or make statements or produce such documents and other things as may be required. So here the important change is that they have allowed an authorized representative. Now, authorized representative may be a, chartered accountant also, a company secretary also, a lawyer also, who can go and now, make this statement. On the face of it, this amendment has been, advertised as an ease of doing business, less harassment of summoned persons, which anyone can now do. And I'm sure a lot of my fellow professionals and, CAs, lawyers, secretaries would. And now the requests will come from clients that now you can attend, and please, you can, I have received a summon, and you can go and attend this summons. My advice is that yes, you can go, but if you are only going to submit documents, the documents should be on the letterhead of the company signed by the summoned person. You, as an authorized representative, shall only produce such documents on behalf of the summoned person. The next important aspect is giving of statements. My clear advice to everyone, I deal with in Delhi, or maybe all my fellow professionals, is don't give any statement on oath before an officer while you are attending summons. I'm sure this may be very lucrative also. Our clients may want to give us ample money also for doing this. This amendment has been proposed here very casually. It is not that casual. Tomorrow, when the prosecution happens, you may be called, you may be implicated, you may be made a party, because you are the one who gave statements. So any person who gave statements, etc., can tomorrow be called in the court to do all this. Like I get a lot of calls from, I'll explain this more, better. For example, there's a PMLA investigation where a bank is, because banks are usually asked by agencies to, come and give bank statements, etc., of the accused and all that. So बैंक को समन आया और बैंक ने उस से ब्रांच में से किसी भी क्लरिकल स्टाफ को या द लोएस्ट लेवल ऑफ द हायरार्की में किसी को बोला कि जाओ ये स्टेटमेंट दे आओ, ईडी में इस दिन जाना है, एंड यू गिव द स्टेटमेंट आल्सो, एंड जो भी होगा वहां पे करके जस्ट फिनिश द वर्क एंड कम बैक. That person didn't know he is going there on behalf of the bank. He is producing that statement, documents, whatever. And then under ED also, there is a similar section 50 of the PMLA Act where they record statements. 50 is slightly different from this, but I'm just saying that those people made that staff record a statement. इतनी सी statement हो कि I was present here on so and so date. I came with these documents. I handed over these documents, etc. चाहे one page statement हो, उस पे sign करा लिया, on oath हो गया, section 50 PMLA का statement है. This person comes back, his boss is happy that you did the job well, etc. He doesn't realize what he has done. 1 year, 2 years down the line, he leaves the bank or joins some another job completely different from bank, or maybe promoted, etc. Whatever he's doing in life. 5 years down the line, he receives a summon from the court to come and witness. Now, this person is no longer associated with the bank. He has no means to go to the court. He has no means to engage a lawyer to go to the court. He is asking me, sir, ye mere ko kyun aaya hai and what should I do? And then when I started interrogating him, he said, once upon a time, I went to the ED office to give some documents. He made me sign on something. So this is going to happen in GST also now. After this, people out of lucrative avenues may want, their employees or their accountants or their chartered accountants or lawyers to go and record statements on their behalf. Please don't do that. It's gonna create trouble for you in future, because tomorrow if the prosecution complaint is launched, you will be definitely implicated as a party or as a witness. So be careful. And as a matter of practice, we should never give any statement on behalf of the client. That is my recommendation to all my fellow friends always. Now coming to 71. 71 is again access to business premises. And so who can authorized, or a person not below the rank of the joint commissioner, etc. is authorized. The rights of the officers is when he's underdoing and accessing the business premises, inspect books of accounts, documents, computer programs, and such other things as he may require, which are necessary for audit, scrutiny, verification, and checks necessary to protect the interest of revenue. Now, though we have read 132, but will still go with 132 one more time, because if we read 132 standalone, no, not with the section 69, then we realize that it is a section for offenses and penalties. 132.1, as we previously also read, talks about a lot of offenses. A, B, C, D are, connected with 69, but it talks about a lot of offenses till L. And if you will see, various offenses have been omitted also from this. Because in last 2-3 years, the government wants to decriminalize a lot of tax laws, and out of that pursuit, they have omitted some of the offenses from it, but majorly it still has a lot of offenses which may not be leading to arrest, but may lead to prosecution. So that is why it is important that we don't read 132 with 69 only. We read with 132 as a standalone section, because this section is important from the prosecution. As I said in the beginning, there is an adjudication, there is a prosecution, there is an arrest. Adjudication may or may not lead to arrest. Arrest may or may not lead to prosecution. But if you have committed any offense out of all this, then prosecution can still be launched irrespective of the fact that you were arrested or not. So it's like prosecution. Some people, confuse prosecution and arrest. Arrest will definitely lead to prosecution. If you are arrested, prosecution complaint will be filed, and there is a circular also for that. But even if you are not arrested, even once, but you have committed any of these offenses, like for example, I'll tell you a case where there is an adjudication going on. Adjudication goes on, and it is found to be a fake invoice case. Like if you have seen a lot of notices which are coming, 4 or 5 days back, it was the last date for notices under 74 for 2017 and 18. So majorly the notices across India are for the fake invoicing or goodless invoices, etc. So for example, you have got a notice. Today there was no arrest. You have got a notice for 10 crore rupees saying that you have supplied goods without invoices, or you have supplied invoices without goods, whatever. And there's a 10 crore demand upon you. That demand 2 years down the line, or maybe in February 25, is confirmed. That demand is confirmed, and there's an order. Till that, there was no arrest, there was no prosecution. But basis that order, prosecution can still be launched, because your case will get covered either in 1A, B, C, or whatever, and they may still launch a prosecution complaint against you. And in that case, there will be two parallel things. The other question you might ask is, sir, ये दोनों चीजें parallelly हो सकती हैं? Yes, there can be a prosecution parallel to adjudication. I have seen now cases where prosecution is running ahead of adjudication also. Principally, it baffles everyone's mind, because when there is no adjudication, there is no quantification. How can you do the prosecution? But right now we are sitting in a regime where this is possible. This is practically happening. Also, there is a circular by CBIC itself which says that the adjudication and prosecution can be parallel as well, and prosecution can be before that also. In arrest cases, rather, they have said that prosecution complaint shall be filed within 60 days in cases of after the bail. So prosecution is a is basically done in the courts where the GST officer files a prosecution complaint before the magistrate. Adjudication is done within the department itself, but prosecution happens in the courts. It's like a proper criminal trial which happens, and once there is a conviction, you can be punished, and the maximum punishment for the offenses which we have seen here is 5 years, 3 years, etc. So we have to be wary of prosecution as well. Simply not getting arrested does not mean that the prosecution cannot be launched. जैसे income tax में भी TDS, default and all these are prosecution can be launched. People didn't take them very seriously in the beginning, but right now, from last 2 years, we are seeing cases where the prosecution complaints are being filed for defaults in TDS, which happened around 10 years back. So any person who thinks that prosecution cannot be done, it can be very well done. And nowadays it is happening also. So our clients have to be aware of the prosecution thing as well. So these are some of the procedural aspects which I have already covered, like authorization for arrest by a commissioner only if there is a tax evasion of more than the threshold limit, etc. Arrest procedure, rights of the accused, etc. They are the procedural aspect. This we have already covered. Yes. So now 2-3 judgments. Like we were discussing the aspect of whether arrest or prosecution can precede assessment. J.R. Chandran Lois versus Superintendent of GST, Madras High Court judgment. This judgment says the Madras High Court has held that the term commits clarifies that the act of committal of the offense is to be fixed first before the punishment is imposed. When the recovery is made subject to the determination in an assessment, the revenue's argument that the punishment for the offense alleged can be imposed even prior to such assessment is clearly incorrect and amounts to putting the cart before the horses. So Madras High Court has said that it should not happen, but I'm telling you, these judgments may not hold good law in another 1 or 2 months, because in Supreme Court there is a case, Radhika Agarwal versus Union of India, which we are all waiting for the judgment, in which all these aspects, like Make My India also just said that first the adjudication has to be done, and then only prosecution can happen. And I'll give you a simple example of this as well. For example, the prosecution may all the offenses are compoundable under GST. Compoundable offenses means you pay some penalty and the offense is closed against you. Now this penalty is determined based on the quantum of tax. This quantum of tax can only be determined in adjudication. So if the adjudication is not complete, how can you compound an offense? So that is why this is one of the argument before the Supreme Court as well, that when you say that the prosecution can happen simultaneously or prior to even adjudication, if today a prosecution is launched and someone wants to compound that offense, how will you compound it? Because the penalty which has to be paid on compounding, cannot be determined because there is no adjudication, there is no assessment which is complete. And even after this adjudication, let me take it to a step further. Even after adjudication, you have appeal stage. You deposit 10%, get this order stayed. Appeal ke baad you have tribunal stage. You have High Court, you have Supreme Court. So unless it is finalized from the Supreme Court level, how can you decide on the quantum or compoundability? So if you say that prosecution can happen before compounding this adjudication, then compounding provisions become redundant. So that is also one of the argument before the Supreme Court. Let's see what Supreme Court says, because the judgment is reserved and we are all waiting for the judgment to clarify these aspects as far as GST is concerned. Now this slide, I just extracted the provisions of CRPC as far as the phrases bailable offense, cognizable offense, judicial proceeding, non-bribe sector are concerned, because the GST laws don't define this. So we have to import the meaning of these offenses from here. Now, some of the another important aspects which come in mind is that whether the provisions of 41 and 41A CRPC apply for the purpose of GST laws. 41A was a provision added in CRPC to say that if someone wants to police wants to arrest someone, they have to give him a 41A final notice. And then if the person appears in a 41A notice, then there is no reason to arrest that person, except for certain specified circumstances. So whether these provisions will apply under GST or not is still a matter of question. To my mind, they should not apply, because then they say GST is a self-contained code, etc. But let's see. I'm again saying this Radhika Agarwal judgment is pending, and all these gray areas, etc., have been argued. And in fact, we were the nodal counsels in that judgment, in that case when the hearing was happening. So all these things have been argued before the Supreme Court, and let's see how the court interprets. As I said, there is a provision to arrest under GST, but there is no provision to come out of that arrest as to how the bail, etc., will happen. So definitely we have to, go under the provisions of CRPC and now the, BNS for the purpose of bail. Bail is 437 and 436 for, bailable and non-bailable. But there's another provision of an anticipatory bail. Whether you can take anticipatory bail in GST or not is a matter of, big gray area, because, and the issue started with this judgment, Telangana High Court, the first judgment on anticipatory bail, P.V. Ramna Reddy judgment in Telangana High Court. This judgment clearly said that you cannot take a 438 anticipatory bail under GST. Why? Because they say there is no specific provision to allow applying an anticipatory bail. They said that the only option to have a protection is Article 226 of the Constitution. You file a writ, and under the writ remedy, you can take a protection from the High Court, but not under 438 of the CRPC. So this judgment was widely criticized. There was an SLP filed against this judgment. The SLP was dismissed, which effectively means that the judgment was confirmed. But then there was a Bombay High Court in Sapna Jain case, where the Bombay High Court in a 438 gave an interim order that no coercive steps shall be taken against the petitioner. Now, this interim order also traveled to the Supreme Court at that point of time. And then the Supreme Court referred the matter to a larger bench, saying that two high courts have taken a different view, and then the matter has to be decided by the larger bench. While the matter was pending, the Radhika Agarwal case has been, done. Apart from this, various high courts, in fact, Delhi High Court also has said that anticipatory bail under GST laws cannot be taken. There is no provision for an anticipatory bail under GST laws, which has created a huge problem, because today you know that you are facing a summon, and then you know you will appear before the GST authorities and they're going to arrest you, but there is no provision to protect you beforehand. So this is a big problem as far as the anticipatory bail is concerned. No, they were when I told you 2019, 20, 21. These 3 years were the years when a lot of arrests in the initial stages happened. All these judgments, PV Ramna Reddy, Sapna Jain, because even people, lawyers were not clear, the courts were not clear what and what not to do. So then ultimately, after a lot of uh, fighting in the courts and all, and directions issued to CBIs, etc. Finally, they came out with the first set of guidelines for arrest on 17 August 2022 by way of a circular, which provided various, guidelines as to how the arrest has to be affected and bail, etc. So this circular, you can read. This basically says that what are the conditions precedent to an arrest, how you have to determine, etc. What is the procedure for arrest, how you have to record reasons of writing, how the arrest memo has to be made, and what is there is a mandatory requirement for adding a DIN number also on the arrest warrant, etc. So all these formalities, then the post-arrest formalities, what has to be done. This also is specified in this circular, and how the bail bond has to be done, how the prosecution complaint must be filed within 60 days of arrest, etc. So this is the circular, which for the first time issued guidelines to be followed by the officers. Similarly, another set of guidelines on the same date were issued for issuance of summons, as to how the summons have to be issued, who can all be called, and in these guidelines they specified that the top management, etc., should not be called in routine manner, etc. So these are also the guidelines issued to streamline the entire process. So these are the guidelines. You can then there are guidelines for launching prosecution as well. That how the prosecution has to be sanctioned, who has to take a decision, etc. So these three guidelines you have to read, and you can understand very simple language in these guidelines are there. In fact, recently on 30th of March 2023, two circulars in regarding to investigations have come up. They are there in this PPT in the bottom, but I think the PPT is quite long. I may not be able to finish them, but they are there in the PPT. So I think Siddhant will share this PPT with everyone. So you can, you should go through. So these guidelines are there, but I must, confess one thing. As lawyers, we see every day, the guidelines may not be followed by the officers in the true spirit and fashion, but that fight will always remain between litigants and lawyers. So we have to take what suits us, and sometimes the clients are also not that saints as they behave before us. So that these things will keep on happening. But these guidelines we can use wherever we want as far as litigation is concerned. Apart from that, I have also added all the slides in this PPT as far as the Supreme Court matter which I'm talking about. So in Supreme Court, we had challenged all these provisions related to prosecution under the GST. So we have challenged 69, 70, 71, whatnot, all the sections in that Radhika Agarwal batch. I've given a glimpse of all these slides which I'm just scrolling, gives the glimpse of all the arguments we have taken before the Supreme Court, and what is the opposite side arguments, what are our arguments. Judgment is not out, it is reserved. Let's see what it can. But for your academic understanding and on what basis we have challenged, I'm sure it is a good read. And if you have any queries, you can always reach out to me. I'll help you in that. But you must, for your academic understanding, you must read, these things, and all are included in the PPT. So this was from my part. If you have anything else, I think we can come to the queries session, and I'd love to take your queries as well.
So we have two queries. the chat section.
Okay, I'll just open them.
So this the first query we had: can there be physical assault in judicial custody? A fear of every entrepreneur.
Now, so in judicial custody, usually there is no fear of any physical assault. So again, I said judicial custody is a custody under the under the monitoring and supervision of the court. So, for example, in Delhi, there is Tihar jail. So whosoever is in the Tihar jail is under judicial custody. Physical assault cases, I should not comment. I should not say that department does it now, because right now the things have changed. In my last 4 or 5 years of experience, I have never seen officers physically assaulting anyone. There were cases 20 years back, 30 years back, which we used to listen from our seniors, that customs wale jo the DRI used to, beat with sticks and all. I have not seen them personally, so I should not say anything about it. I have not seen any physical assault. If you try to assault an officer and there is a reaction to it, I don't know how that works. But in judicial custody, there is no threat of a physical assault unless you are in the jail and you take a fight with the fellow intimates or fellow inmates or the jail authorities, or you want to slap a superintendent. I don't know then what will be the opposite reaction. But yes, there is no risk. If there is a risk, if there is a complaint of a physical assault, you can immediately file an application before the magistrate, and magistrate takes cognizance of it.
We have a second question: that who can be arrested? Like, do they have authority to arrest anyone related to or
Yes.
unrelated to the company?
Yes. Your query. Let's read 132. First line. I'll just read 132. First line is: whoever commits or causes to commit and retains the benefit arising out of any of the following offenses. So there are cases where people create companies in the name of their drivers, maids, guards, and they on paper they are nowhere. But even those people can be arrested because it says whoever commits or whoever retains the benefits arising out of it. So if you have done any of the offenses, for example, you are an employee, you are working on the you are not even an employee तो चलो related हो गया. आप एक ब्रोकर हो जो फैसिलिटेट करते हो ये फेक इनवॉइसेस वाले लोगों को, जो एक इनवॉइस देते हैं और एक गुड्स देते हैं, आप बीच में उनके मीडिएटर हो. इवन यू कैन बी अरेस्टेड. देयर इज अ प्रोविजन under 132 ABCD में you definitely fall and you can be arrested.
But sir, isn't this a very big open statement? For example, if tomorrow Reliance commits a fraud and I am a shareholder benefiting out of it.
No, that's too far-fetched. That's too far-fetched.
But the close related shareholders of a private company can be.
Yes, so benefits arising out of मतलब अगर आप कुछ गलत काम कर रहे हो और जैसे आप मान लो ये जो जिसको हम अपने कॉमन लैंग्वेज में फेक इनवॉइसेस वाला काम बोलते हैं, अब उसमें जो कमीशन बीच में ब्रोकर रख रहा है तो उसका बेनिफिट्स वो रख रहा है. तो इन दैट सेंस द बेनिफिट्स वो शेयर होल्डर्स तक नहीं जाएंगे, बेनिफिट्स वो सब आपस में बीच में खा पी जाएंगे. सो इन दैट सेंस whoever retains the benefits.
So again, sir, we have one interesting question: is there any monetary limit for such brokers?
5 crores?
5 CR. So 5 CR is individually for the total transaction or for individual persons? For the total transaction.
Again, a gray area. अब मेरे से आप ये भी पूछोगे कि 5 ईयर पर ईयर है या 5 ईयर पूरा कंबाइन होना चाहिए. सो अभी तक इस पर क्लैरिटी नहीं है, बट जब उनको अरेस्ट करना होता है तो वो 5 करोड़ से ऊपर का फिगर बना के, चाहे वो 1 साल का हो चाहे 5 साल कंबाइन करके हो, दे विल मेक अ फिगर ऑफ 5 crore rupees and arrest you. But to my mind, it is it should be transactional wise and year wise, because GST में वैसे भी adjudication and all is year wise only.
So 5 crore is the tax amount, just the tax amount.
Tax amount, yes, not the value.
Without interest, penalty, anything.
Yes.
If there is any other question, you can ask or share in the chat.
It's a very, I mean, it's a very interesting topic. We do it day in and day out. So I also love reading about 69 102 and but I don't know, but as CAs and all, we should really focus on this and 70 वाला provision बड़ा ध्यान से रखना जो भी नया है authorized person वाला. So that's advice.
So after this section, any demand of more than 5 CR, the client is like, please just save us any or else they will issue an arrest warrant. So now
Sorry?
that's the thought process the businessmen have today. If they are receiving any show cause of 5 CR and above, so they are like, sir, please resolve it at the best because or else they will issue an arrest warrant tomorrow.
Yes.
तो कहीं ना कहीं वो डर है.
वो डर है, बिल्कुल है. और वो डर हुआ है क्योंकि वो सर्कुलर में लिखा हुआ है कि आप जो है प्रोसिक्यूशन और अरेस्ट इमीडिएटली कर सकते हो. यू डोंट हैव टू वेट फॉर एडजुडिकेशन. दैट इज देयर.
So I guess that covers exhaustively the arrest provisions of GST law, even though the sections are like, I guess, 1-2 page maximum in total.
I told you it's a 3-clause section, but it's if you link it, it's a very big section.
Yeah. So everything. So the Shubham is asking which circular number, so that would be written in the PPT that you will be sharing with us.
Yes. The prosecution circular of 2022.
Yes, sir. So, sir, do share the PPT with us. We will share with the entire group.
I will.
Yes, and the people who are not able to join. Yeah.
Yes.
So, thank you so much, sir.
And I wish everyone all the best for the future lectures and yes, for this course.
So this
and thank you
was
so
an
much for having
amazing.
me.
Yes, so this was an amazing session covering the every small aspects of the arrest from what was pre-GST to today and what will be coming in future case laws. So everything exhaustively, sir. Thank you so much for your time, sir. And it was really amazing to know so much about the arrest, even though we don't face it in the daily life. But this is something which is extremely important for all businesses today, no doubt. So thank you for your time. It was a really pleasure for us, for you having here in ACA to take our third session on this advanced certificate course on GST litigation. Thank you for your time, sir. It was a pleasure, sir.
It was a pleasure to be with you all. Thank you.
So all of us, let's meet tomorrow, same time, same place, same link for the next session on advanced GST litigation. Thank you. Thank you, sir.
Thank you. I'll just leave.
Yes, sir. Thank you, sir.